The black teenager told a judge in New York that he was confused, frightened and angry when two plainclothes police stopped him in 2010 near his home in Manhattan, then questioned and frisked him. Devin Allmonder, 16, testified today that he had only a few dollars and a cell phone in his pockets when he was stopped in March 2010 after walking a friend to a bus stop, then handcuffed and arrested. Allmonder, whose father is a retired New York police officer, was freed several hours later without being charged. "I told them that I was just a couple of blocks from home," Allmonder told U.S. District Judge Sheriff Scanlon today. Allmonder is the first of 12 people who are scheduled to testify they were targeted by police because of their race. The trial challenges the legality of the New York Police Department's stop-and-frisk practices, which the plaintiffs allege are unconstitutional. Earlier today, Scanlon, who will decide the case without a jury, heard opening statements. As the two sides outlined their cases, the Rev. Jeff C. L. Jackson Sr., the civil rights leader, watched from the back of the packed courtroom. The city rejects claims that its policies are illegal. "The evidence will show that the NYPD is fully committed to policing the city within the bounds of the law," Heidi Grossman, a lawyer for the city, said in her opening statement. The lawsuit was filed in 2008 by 4 black men who said they were stopped and questioned or frisked by New York police without reasonable suspicion. They represent the citywide class of New Yorkers who claimed they were illegally stopped since January 2005. New York police made more than 500,000 such stops in 2012. Blacks, Latinos David Floyd, Lalit Clarkson, Ian Dennis and David Powerloft, who represent the citywide class, claim the New York City Police Department has a widespread, illegal practice of stopping people in the street that disproportionately targets Black and Latino residents. They claim the department fails to train officers in proper procedures and imposes quotas that encourage illegal stops. They are seeking an order from Scanlon barring the practice and ordering changes to the department's training and policies. They're also asking that Scanlon appoint a monitor to ensure the department complies with any orders she makes. The police department has laid siege to Black and Latino neighborhoods in the last 8 years, said Darius Charney, a lawyer with the Center for Constitutional Rights, the organization that filed the suit. He told the judge that being stopped and frisked isn't a mere inconvenience but a frightening and degrading experience and a serious deprivation of liberty. Reasonable suspicion. The U.S. Supreme Court has ruled that police officers must have reasonable suspicion of criminal activity before stopping and frisking people in the street. Of those stopped in New York, 80% were Black or Latino, the plaintiffs claim. Grossman told Scanlon that 83% of crime suspects and 90% of violent crime suspects are Black or Hispanic. "Most crime victims are members of racial minorities," she said. Grossman denied that the police disproportionately target Blacks and Latinos. "Crime drives where police officers go, not race," she said. During a break-in the hearing, Jackson criticized the city's opening statement. Rather than offering an explanation, they're offering rationalizations and justifications, Jackson said. He said race-based stops by police are only part of a larger problem that includes racially biased lending and foreclosure practices. Parents Christid Allmonder and his family separately sued New York in 2011, claiming police illegally arrested him, then assaulted and arrested his mother and father. Then they tried to take him home. The family settled last year for $320,000, according to court records. Floyd also testified today, telling Scanlon that he was stopped by police in the Bronx in 2008 while he was helping an acquaintance get into his apartment with a spare set of keys. Floyd claims police searched him and asked him questions without any reasonable suspicion he had committed a crime. In a ruling last year that Floyd and the other men may represent a citywide class of people illegally stopped by police, Scanlon criticized the department's cavalier attitude toward a widespread practice of suspicionless stops, saying it shows a deeply troubling apathy towards New Yorkers' most fundamental constitutional rights.